And topping the news here at 5:30, Buffalo Mayor Sean Ryan today took questions from the media after signing an executive order prohibiting the use of city resources for federal immigration law enforcement without a judicial warrant.
Ryan saying he's concentrating on what he has control over, which is making sure every City of Buffalo resident, regardless of immigration status, can feel free and safe to interact with City Hall, police, and other city resources. To talk more about this and what it means for residents, we're joined now by immigration attorney Rosanna Berardi. Rosanna, thank you for joining us.
Thank you.
Well, today the mayor said, quote, "We don't want people afraid to come to City Hall to get a dog license or call police. That will not trigger a federal response." Can you just kind of deep dive into that, exactly what this means today?
Sure. So the executive order that was proposed and signed by Mayor Sean Ryan really says that anyone in the United States who violated the immigration law from a civil perspective, meaning overstayed their visa, will not be turned over to the criminal aspect of the government, meaning the police or the cops in the city of Buffalo.
Rosanna, a lot of this discussion is sort of focusing on or centering around the type of warrant that is being used by DHS and other agents, either a civil or an administrative versus a judicial warrant. Could you kind of lay out the differences here and why that is such a key component of this broader conversation?
Sure, it's a very complex issue, but this is how it works. A judicial warrant is issued by an impartial judge that the law enforcement goes in front of and says, here's some evidence, judge signs off, person can go in. We're talking about warrants for entry to someone's personal home because the Fourth Amendment of the U.S. Constitution says no unreasonable search or seizures. Now, the administrative warrant that's issued by Homeland Security is for individuals who have a final order of removal. That means they've been through all of the processes and procedures in immigration court and criminal court. The last step is to remove them from the U.S. The play on these warrants and the issue and complication is going into someone's home. Previously, ICE could only take people with administrative warrants in the public purview, so on a sidewalk, in a bus station. Now we're seeing a trickle down into personal homes, which is in violation. So it's very muddy. If someone knocks on the door, I mean, people are saying, ask what type of warrant that is available. And unless it's a judicial warrant, you don't have to let someone into your own personal home.
Now, when it comes to that very specific sort of difference there for those warrants, what is a person sort of supposed to do in reaction to those? I don't think the average viewer is going to be having a knock at their door at home. But people out in the community, they should know what their rights are. And in specific to that sort of Fourth Amendment, legal search and seizure of someone's home or property, is it that this issue, Rosanna, has not yet been tested by the courts? In other words, the Trump administration or whoever would sue them, this has not been a decidedly finalized issue in the courts yet. Is that why it's being tested here?
Yes, and really a whistleblower came out last week and we all found out about this memo from ICE dating back to May of 2025, stating their procedure of being able to knock someone's door down with an administrative warrant, which in the past they've only been able to do in public spaces, has been issued by ICE. Now, this will certainly go up to the courts. As of right now, they are only supposed to do it in public spaces, but this remains to be seen. It's a very conflated issue and very difficult to explain because on one hand, we have the municipality of Buffalo saying we're not going to cooperate, but they're only saying that with respect to civil violations. The issues regarding the warrants really pertain to criminal issues or final removal orders of deportation.
Got it. You're saying that this does contradict that memo, though, Payton versus New York back in 1980. Will you explain that?
Yeah, so that is a long-established court case from 1980. The U.S. Supreme Court said your home is your sanctity. It's your special space. Nobody can come in unless they have a judicial warrant that's issued by an impartial judge. The problem with these administrative warrants is that they're issued by the agency that wants you removed, which is Homeland Security. And the Supreme Court said back in 1980, those warrants are not sufficient because they're not impartial. Now, long established, part and parcel of the Fourth Amendment, but this one's going to be challenged at a very high level. We may have the Supreme Court visit it at some point, but for right now, we're in that weird gray area where we're not sure how it's going to shake out just yet.
Always important to be vigilant, and the way to do that is being armed with information. Rosanna Berardi, thank you so much for joining us this evening.
Thank you.
All right, Rosanna, thank you.